Okay.
All right. I'd like to call this meeting of the Inland Wetlands Commission to order on February 26th at 7:14 p.m. Excellent. Let me see here. First order of business, I'd like to introduce myself. I'm Danielle Monroe, the chairwoman. I'd like to go down the line and invite our other commissioners on the screen. Nico, can you go next? We have to unmute you.
You are muted, Nico.
I don't know that. Can someone unmute him since he's driving?
I can't.
Oh my God, Dave.
There you go.
Dave, I'm gonna kill you.
Nico, introduce yourself.
What?
Nico, can you introduce yourself for the commission, please?
I can't. I will introduce myself now. Nicholas Jordan, Vice Chair, Commissioner.
Thank you.
Thank you.
Pat,
Patrick Parafor, alternate.
Jay,
Jay Oldham, alternate.
thank you. I at this time would like to seat both of our two alternates.
Sure. And just as a quick reminder, in case anybody doesn't know, Dave McCollum and the Wetlands
Oh, I'm
agent.
sorry.
Amanda Martinez, recording secretary.
Okay.
Sorry, my bad. Thank you, guys. I'd like to go ahead and seat Jay for Laura.
Sure.
Sure, doesn't really matter. Okay. And I'd like to go ahead and seat Pat for Kevin.
Okay.
Okay.
Very good.
All right. So we're all on boards today.
Okay.
Mr. McCollum, do we have any changes or modifications to tonight's meeting agenda?
Thank you for asking, Madam Chair. We do not.
Okay. So I think that leads us to our first order of business, which is a site plan review of number 7 Rockwell Road.
That's correct.
Okay. Do I need to read it?
It's worth reading the application number, the address, and the description for the record.
Application number is right here under the.
That's right.
Okay, so the application number is IWC-2023-10, and the description is unpermitted excavation and or fill activity along and within an established water course, which is Lime Kiln Brook. Do I need to read all of the?
Nope.
Okay. And so with that, I'd love to ask if there's anyone here on who would like to speak on behalf of the applicant.
If I may. For the record, Neil Marcus, Colonel Wolf, PC 158, Deer Hill Avenue, Danbury. And I'm here on behalf of the applicant, but obviously I'm joining this hearing or this meeting, the whole process kind of late because I was not involved back in September when this all started, but Mark has been kind enough to give me a pretty good history of the proceedings. So it's my understanding that the application that is before you was filed in response to an order to correct that was issued on September 6, 2023, and that was followed by a revised order to correct that was issued approximately a week later on September 14, 2023. And in that order, my client was ordered actually to file an application. Item number 3, an application be submitted to the Wetlands Commission on or before their October 23rd meeting, which he did. And that's what you're carrying on your agenda is a site plan application. But when he came to see me and I read the orders, I went back and I looked at the regulations for the commission because this didn't seem proper. And what I was aware of is, of course, that section 3.2 of the commission's regulation. And by the way, this is not unique to the Bethel Commission. This language appears in almost every set of inland wetlands and watercourse regulations in the state of Connecticut, because it reflects the history of the act itself, which is to exempt certain operations and uses as of right. So in 3.2, paragraph 3, the following operations and uses shall be permitted in inland wetlands and water courses and upland review areas as of right. Well, the first one, of course, is farming operations, and we know that that's been a source of contention, but it's pretty well accepted at this point. And that includes road construction, relocation. There are a bunch of bullet points. The second thing is residential home. You can obviously have a residential home for which a building permit was issued. And again, there are certain bullet points. But what applies to this particular situation is paragraph C. Uses, they're called residential accessory uses. Uses incidental to the enjoyment and maintenance of residential property. Such property containing a residence and defined as equal to or smaller than the largest minimum residential lot size permitted anywhere in Bethel. Such incidental uses shall include maintenance of existing structures and landscaping. That's what people often overlook. It's that language right there, structures and landscaping. But you'll not include removal or deposition of significant amounts of materials from or onto a wetland or water course for diversion or alteration of a water course. So the first thing you have to determine is A, is this a residential property? It is. B, is the work that my client doing landscaping? And quite honestly, it is. It's his actually profession as a landscaper. And then the next question is, what are significance of amounts of materials from or onto a wetland or water course? Well, that's the issue that is not clearly defined anywhere. But quite honestly, if you look at the work that my client's doing, he's rebuilding stone walls. He's basically stabilizing a riverbank that has been eroded away, and he's removing dead trees and growth from the bank itself, and more importantly, from the river, from the stream that runs behind the property. And that is considered to be normal residential accessory uses as defined in the Act. But then there are other sections, the second section of the Act, which makes us either a little clearer or a little less clear, is section 3.3, which are non-regulated uses. So paragraph 1 says, to carry out the purposes of this section, any person proposing a non-regulated operation, use, shall prior to commencement of that use, notify the commission on a form provided by it and provide the commission with sufficient information to enable it to properly determine that the proposed operation and use is non-regulated. My client made a mistake, and I'll be the first one to tell you that I told him when he came into the office, before he started the work, the landscaping that he was doing on his property, he had an obligation under the regulations to notify the commission and fill out your form for notification of non-regulated activities. That wasn't done. What was done instead was the filing of application that was not really required in response to the original order to essentially cease and desist. And then the commission has to rule that the proposed operation and use is a non-regulated activity. So at this point, we're going to have to consider the application before you, the notice that you're going to have to rule on. Then the operation and uses, paragraph 3, the following operations and uses shall be permitted as non-regulated uses in wetlands and water courses and upland review areas, provided they do not disturb the natural and indigenous character of the wetland and water course by removal or deposition of material, alteration or obstruction of water flow or pollution of the wetlands and water course. We've got the opposite. What we've got is we're not altering and obstructing the water flow. My client's actually pulling dead wood out of the water so that it can flow by it. And he's also stabilizing the banks so that they're no longer falling into the water course. So that's what he's doing, and that's pretty clear from the application that you have in front of you and the report from JMM, which again is a step beyond what a lot of people will do in non-regulated activities. But here, that report clearly shows the conditions and the work that's addressing the conditions from an environmental perspective. So the section 3 goes on to say, A, conservation. Conservation of soil, vegetation, water, fish, shellfish, wildlife, etc. Provided that such operation or use may include, but is not limited to, minor work to control erosion or to encourage proper fish, wildlife, silviculture management practices. Outdoor recreation is allowed as a non-regulated activity, camping, boating, that type of stuff. That's where we find ourselves, that the applicant made an error by starting work that is not regulated and work both. He's got two types of work. One is uses allowed as of right, and one's non-regulated. The problem is he didn't tell the commission before he started the work. Now the commission has before it a detailed description of the work that's being done, including a report from JMM, which is dated October 15, 2003, that identifies the nature of the wetlands and watercourses adjacent to the residence. And in there, of course, you've got photos and maps and pictures of the conditions that Jim McManus found. Again, there's a picture of a temporary work bridge, which, interestingly enough, the actual construction of that bridge is to not be in the watercourse itself. I saw it personally. I went out there. I had to marvel at the engineering that Mark went through to make sure that his work platform was not in the water, and his work platform was portable and removable and doesn't even stay in place overnight. So he's taken a lot of steps to protect the environment and to do the work in an environmentally sensitive manner. So you're looking at, if you look at the JMM report, he talks about the areas of recent disturbance where the bank was currently being undercut, eroded by the flow of the brook. That's his photos attached. And that the work is to fix the bank from further erosion and undercutting by the use of a mixture of rocks and soil, which are natural materials that exist on the bank. And basically he's taking a bank that's falling down and he's actually just putting it back up. And that's the nature of the work. And it says that the current, Jim McManus goes on to say, this current undercutting erosion has led to significant bank erosion and tree instability, which poses a threat to existing structures on the property near the western bank. Therefore, the activities, in JMN's opinion, are activities suitable to repair eroding banks and have caused no significant short-term or long-term water quality, habitat, environmental issues in the lime-filled brook or its fringe floodplain and wetlands. Actually, Jim comes to the conclusion, rather one can say that the bank repair has helped with the eroded sediment and has been transported downstream for decades. And that although no impacts have accrued to the regulated resources, it is JMN's recommendation that a few shrubs be planted along the eastern bank to ensure stability. So JMM has come up with its restoration plan, which quite honestly is no different than what Mark went out to start in the first place. That is to stabilize the banks with the rocks, the dirt, and to plant them with shrubs so that they don't erode. That's really what's before you this evening. And that's really what's been before you for the entire time that this matter has been on your agenda. The order to correct assumes that the work was a violation, and we disagree, 100%. We disagree. There's been no finding to support the fact that the work is not in compliance with section 3.2 and 3.3. And as I say, people are allowed to landscape. The history of inland wetlands and watercourses, which is basically my entire history of law practice, because quite honestly, I was sworn into the bar about a year after the Inland Wetlands and Watercourses Act was passed in the state of Connecticut. So I grew up in land use when the land use agencies and the DEP were feeling their way through. But it is clear from day one that there were a couple of things that the act wanted not to affect. One was farming. There, again, my other history is I was a farmer. I'm from a long line of dairy farmers. Anyway, farming in Connecticut is very disruptive to the environment. There is no question. And the fact is, you say, well, if they're worrying about protecting the environment, why did the legislature exempt the farms? Because they're the worst offenders. And the answer is because they would have killed the farming industry, which is already dying, and it's almost dead anyway. But they would kill it if they were to have put regulations on farming activities. So what happens to people who want to do their landscaping, happen to have a brook running behind their house, and they walk out in the morning and the trees falling down from a storm? Can they not take those out? Of course they can. And if there are rocks sliding down the bank, of course they can. The answer is that there was an intent at the legislature to allow people to do normal maintenance and landscaping of their property. But of course, like every other statute that leads to regulations, you have to put in something to add some confusion. And the confusion is the undefined terms of what is in fact significant amounts of material being placed into or taken out of wetlands or watercourses. We know what a diversion or alteration of a watercourse is. That's pretty clear. You change the direction, or you dredge it and you alter the actual watercourse itself. That's not occurred here at all. The watercourse flows exactly where it did. Actually, it probably flows significantly better than it did, but no materials have been deposited into the watercourse. And to the extent that the banks of the watercourse have wetland soils because of the banks of the watercourse, obviously when you restore the bank, you're putting material back where it came from on the wetlands. So the question is, what is a significant amount? And we submit to you that you've got an opinion from JMM that would indicate that there is not a significant amount, and we have no contrary evidence from the commission or from anybody who has studied this property that that's not the case. So that's one of the issues. And the other issues, of course, is, to determine the disturbance of the natural indigenous character of the wetlands or watercourses. And we will submit to you, again, relying on JMM, that in fact, the work that Mark has done has not disturbed, it's actually restored the natural and indigenous character of the brook and the wetlands. And then, of course, the last issue is that in conservation, the regulations encourage this work as long as it ends up in conservation. And it includes, but is not limited to, I love that. It includes, but it's not limited to minor work. So it could be more major work. That's where these regulations, of course, speak out of both sides of their mouths. So here we are. The commission has before it an application that describes the work that we claim is done as of right. It was filed in response to an allegation that there was a violation to which we disagree. But at the end of the day, I got a guy here who's taken a rundown piece of property along a very deteriorated portion of the Limekiln Brook. And if he finishes this job, it'll be for Architectural Digest to photograph, because the stonework that he does do, and I know it's, Mark, have they seen any of your work in other places?
Yes, they have.
Okay, I've seen pictures. The stonework's incredible. So our position this evening is that we would like to work with the commission and with David, obviously, as the enforcement officer. And if you have any suggestions as to how you want to see this work done, you've seen how Mark's doing. He's not doing it with a lot of heavy equipment. He's doing all this by hand. I mean, you couldn't usually people are offended by the well-intentioned work that requires destruction of wetlands to bring in heavy equipment. It's not the case here. He is doing work by hand and will continue to do this. He doesn't want to be in violation of any of the regulations, but at the same time, we want to get this project moving and finished, especially now that the weather's breaking. If the commission has any recommendations or conditions that they want to reasonably apply to the work that he's doing, we'll do it. Otherwise, the issue is, do we want a court of law at some point to determine what's major, what's minor, whether this is restorative, whether it's conservation, or whether it's not? And from our perspective, we think that this commission has seen enough evidence of the work itself, the conditions that existed prior to the work, and you have to reach the conclusion that it's within section 3.2 and 3.3 of the regulations. So that's where we are. I mean, basically, we're here to take a stand. We did it. We took a stand. But we're not here to have a fight, because in reality, we'd like to end up with a completed project, and it's a landscaping and a restoration project that the commission can actually go out there, look at it and say, this is nice, this is terrific. Because I think that's what we're headed to. Again, I'll mea culpa, we are guilty of not doing this before we started the work, but I will tell you that today in Bethel, there are probably 20 or 30 other people out there looking at the springtime about to do the same thing. They're about to start out in their landscaping and never even consider what the inland wetlands and watercourses regulations require them to do. Because I've been before this commission for many years, and there's rarely have I seen anybody in front of this commission with their landscaping as of right. And people just don't think about it. They say, well, you know, I'm gonna make a new flower bed over there. And they're not even considering the fact that they're within 5 feet of a wetland or a watercourse. All of that requires notice to the commission, because it's an activity you can do, but you got to do it. So we're guilty of that. We're just as guilty as the rest of the crew. But at this point, we've presented to you the work that has been done, the report as to its environmental impact, and we'd like to finish the project with the commission's report, either if you feel compelled to grant us a permit that we don't think we need, or if you just want to say, you really don't need the permit, but here are the things that we want you to do as part of this work, we'll do it. Because that's essentially the type of work that my client does anyway. As I say, he may not be good at the bureaucratic side of it, but when it comes to the actual work, he's terrific. So that's where we are. I'm sorry this gang couldn't have been here.
Thank you, Mr. Marcus.
Thank you.
Does that close your remarks?
Good.
All right. I'd like to just ask the commission members if they wouldn't mind holding any questions or comments. I'd like to give Dave the opportunity to respond first, and then I'll open it up to the rest of us. Dave, did you have comments that you would like to offer?
I do, Madam Chair. Thank you very much. It will not be nearly as eloquent in delivery as Attorney Marcus is, but I'll do my best.
It'll probably be more meaningful as a result of that.
I do have a memorandum that I would like to distribute to the commission, which in this case is just in Yale, but I will have it up on the screen shortly. I'll give a copy to you and your client, Mr. Marcus here. You're welcome. Okay, I'm going to try to do this as slowly as I can. If you need me to slow down as I share this, just let me know. It should be coming up on your screen shortly. Okay, can everybody see this?
Yes.
Pat, Jay, can you see this? Nico?
They're muted. I see that Pat is saying yes.
Okay.
Yeah.
I could see it a minute ago now, but
I can see it. It's a little small, but I can see it.
Okay, let me try to scroll in on it here. There we go. How's that?
Good for Pat, good for you, Jay.
That's good. My old age is good.
Good here.
Great. Nico, can you see it?
I just can't figure out how to like go to go to the next screen options. Yeah, I got it. Okay, thank you.
Got it now?
Yeah, I'm gonna need somebody to like fill me in on it. I can't like read the whole thing. So is this the section that Mr. Marcus quoted from?
No, Dave's comments in response to the application.
Does anybody have any questions, or do people mind if I just keep going through my presentation or through my comments? Okay, I'll take that as a no. Okay. So yeah, to paraphrase some of what is in my memorandum to the commission, and just to clarify this up, for all intents and purposes, the terms exempt or exemption, permitted use as of right, uses permitted as of right, they're all meant to be one and the same. There have been a fair share of court decisions by both the appellate and Supreme Court where they use the terms interchangeably. So if I dart between the two, that's what I mean to say. So I just want to make sure that's clear. I'd like to note that Attorney Marcus hit one of my comments that I was going to address in terms of the process for claiming an exemption, and this goes for non-regulated uses and uses permitted as of right, in that the prospective exemptee, if I'm going to coin that correctly, they have to claim the exemption first before any work begins. In conducting the work before submitting or giving you any kind of indication that they want to go forth with this, their right to try to claim an exemption or substantiate that they have an exemption, it's kind of it's forfeited. And so when we're talking about the applicant's request to be considered for an exemption, the commission should consider that for your intents and purposes, it's really a non-starter, or that conversation is anyway. If you wanted to give the applicant the benefit of the doubt, there was a show cause hearing that you conducted, that you gave the applicant notice as to when it was going to be held, its location, and all of this was done to give them a chance to state their case as to why they had done what they had done. It should be noted for the record that the property owner was not present for that show cause hearing. So you had to rely on information that was provided by myself, the agent, and by the complainant, which it should also be noted for the record was the driver for this entire situation. If you were to go into the complaints, which I'll make sure is added for the record, the nature of the complaint / the alleged violation, which was submitted on October 1st, 2023, states, and I quote, "moving rocks in waterway / altering flow of watercourse." They provided photos that essentially reflected what appears to be stones or rocks that have been taken out of the channel of the watercourse and placed as part of the landscaping or whatever the applicant wants to call the work that they have done. So this whole situation was prompted by a violation. Let's just make sure we're clear about that. And
Dave, I gotta interrupt you for a second. Can I chime in? This is Nico.
Nico, can you just hold your comments until Dave is done speaking, and then I'm going to open it up to commission members to make comments?
Okay, even if I feel like he's okay.
Yep, just
Yep.
give him a
Okay.
chance to speak, and then you can have an opportunity to comment.
It's not on us, or the commission should consider that it's not on you to find whether or not a use is exempt or not. The applicant has to substantiate that, and that would go for whether a use was exempt or it was not exempt. The commission has the right to request information. If someone's going to claim a use is exempt, they have to say why. None of the information that the commission has received to date really substantiates that. And before Attorney Marcus gave his verbal testimony tonight, he really had nothing to speak to that effect. I could go into notes and reports, or I don't know if report is the right word, or documents that have been issued or not issued, but they're available for the public's interest, from Attorney Janet Brooks and from Attorney Mike Ziska. Janet Brooks has written a fair share of excerpts in a newsletter that's distributed by CACUAC, the Connecticut. I'm not going to try to go through the acronym right now, but it's called Journey to the Legal Horizon. In her version of the Journey to the Legal Horizon, I believe it's from 2015, but I could be misquoting that. She essentially goes into she gives us a summarized takeaway message that describes how exemptions have been previously held or reviewed by the appellate and Superior Court. I can distribute that now if you'd like. I can put that up on the screen. But I think it may just be easiest if I read it. Attorney Marcus, if you want a copy of this as well, I'd be more than happy to give one to you. Sure. I'll go through some of the bullet items that are on it. Just to be clear, she is in no way acting as our counsel, but I think just because of how broadly this could be applied, I think it was worth the commission considering what was written here. Number one, those people believing that their activities fall within an exemption, the quote exemptors and quote are required to have those activities declared exempt by the municipal wetlands agency before undertaking those activities. Two, if during the agency's review, the agency seeks additional information relevant to its consideration whether the proposed activities are exempt, the exemptor is required to provide it. Three, if the agency has ruled against the exemptor as to any proposed activity and the exemptor still wishes to undertake that activity, the exemptor must take an appeal to the Superior Court contesting the agency's decision. I would interpret that, just to divert on that quickly, as to say, you've already held a show cause hearing. You've determined that, and when I say you, I mean the commission. You've determined that the course of action that you have requested the applicant to provide is the appropriate way to deal with the situation. So there really is no undo button for that, at least in my opinion. To go back to the list, number 5, if the agency brings an enforcement action in court against an exemptor, the exemptor cannot claim that the activity is exempt unless the agency has already declared the activity is exempt. Number 6, when the agency brings an enforcement action in court, the exemptor may not file an independent court action asking for the court to rule on whether the exemptor's proposed activities are exempt. There's another decision that I can go, or there are 2 decisions where a lot of this is stemmed from. The first of which Janet Brooks cites at the very top of her article, which is the word I was looking for. The town of Canterbury et al. Oh, no, that's the wrong one. Susan Jorgensen, excuse me, Inland Wetlands Enforcement Officer of the town of Eastford versus Darlene Chapdelaine et al. And then the other one, which Attorney Mark Ziska cites, Town of Canterbury et al. Versus Christopher Deoje et al. They really say the same thing. It's also worth considering that the commission is not trying to be punitive to say that what has been done cannot be kept. I think the commission has been really good about being about not making any such statements prematurely. You have waited at this point 3 months for the applicant to give you information to say, I've already done some work. Here's some information, some additional information that you've requested that essentially states, the existing conditions, gives you a proper site plan as to why, or that shows where the activities are taking place. And furthermore, other supporting documents from a wetland scientist, engineer, anyone that can speak to why what has been done does not cause any adverse direct impacts to the water course. Well, I guess first and foremost, the section of the water course that's on the applicant's property, but to a similar extent, any adverse impacts to water courses on abutting properties. That's why you had a verified petition to intervene submitted by an abutting property owner, because they were concerned that the stones that were being taken out of the water course were redirecting the flow towards the applicant's or towards their property, and the stones being relocated on the applicant's property were causing the water to head towards the intervener's property. To date, there has been nothing that has substantiated that is not an issue. You as the commission have been concerned about that and have expressed that concern throughout the entire process. I'm happy to answer any questions, but you should really consider those facts with regard to what Attorney Marcus has presented to you. That's all I have for the moment.
Thank you, Dave. I'd be happy to open it up to commission members, but rather than stepping on each other, can you just let me know if you have comments that you would like to? Nico, you're muted at the moment. I can't see you. Did you have comments that you wanted to add?
Yeah, I can wait if there's other people who want to go.
It doesn't look to me like Jay or Pat are asking to speak at this time.
Pat probably wants to. Let Pat go.
Nico, go ahead. I'll wait.
Okay.
No, Nico, go.
Okay. Thanks. Hi guys. Thanks for putting up with my driving. I'm in Vermont. So I guess I have some questions for Dave, and also Mr. Marcus. And for the I guess my first question is for the homeowner. What's his last name again? I'm sorry, Mr.
Bjorken?
Mr. Bjorken. Thank you, Danielle. Did the stones used for the stone walls, where did they come from? Dave actually stated in his comments, but
Do you want to address that to the applicant?
yeah, so I was wondering where the stones come from. Dave said that they came from the river itself, that we have that on record.
Okay, so we'll allow Attorney Marcus to respond.
If you'd like to.
Mark, yes. The question for the commissioner is, where did the stones come from that you're using for the stonework on the site?
I had a friend who delivered them.
Okay, you know where they came from? Where did he get them? Newtown. Nico, the stones came from a site in Newtown.
Okay, so that's too bad. But okay. So I feel like so well, I just blew up the whole thing then. But basically, if the stones came from the river, like David said, and I imagine some did, but I guess it sounds like some did not. Then
Let's try not to speculate on.
You want let me ask that question, Nico, if I can for a second.
Mhm.
Mark, the allegation is that you removed stones from the river. Did you remove any stones from the river? Did you take rock out of the river?
No, these stones came from a site in Newtown.
Yeah, but
Okay.
say,
you guys should really hear me out before
Hold
you.
on for a second, please.
the question is, did you take any rocks out of the river?
The rocks with the ball is not from the river.
But did you take any rocks out of the river at any point during the construction process is the question.
If you know.
There might be 3 rocks as big or something. It just because I had to fit them together.
So the answer is yes, there were some
2 or 3?
stones that were
Yeah,
removed from
2
the
or 3,
river.
yeah.
Okay, does that answer your question, Nico?
Yeah.
99% of the stone came
Was
from
brought in.
Outside.
Okay, so I don't know if you can hear Mr. Bjorken. He's
Yes.
stating that
Yes.
a few rocks came out and for the most part, new materials were brought in to be introduced into this project.
Okay. That's a new development for me to hear. I thought that we were under the pretense that they came from the river, which
Mark, Nico, if I can just steal Mark's again, if I can address
Wow.
that.
sure.
If you go out and look at the site, do a site,
We've done
Yeah.
a sidewalk.
you'll see that there are an extraordinary amount of rocks still in that river. I mean, the river has not been altered
Okay.
significantly by taking rocks out. I mean, they're there.
So you guys aren't following me because you're not letting me finish what I'm trying to say. Basically, if the rocks come from the site, if they are harvested from the site and then redeposited or replaced on the same site, then there is no change in volume of the flow in the river. So if the volume that the rock takes up and then is moved to another part of the river on the bank, then you have no change in volume of the flow of the water. I've been waiting for somebody to say that. So now I said it. So, so unfortunately for you guys now that it sounds like the rocks came from somewhere else, you know, obviously this is the thing that's permitted as of right to maintain some residential property, as stated in the regulations. But the question becomes if significant, as Mr. Marcus had said before, if significant, quote unquote, significant amounts of material are removed or deposited. So those are two different things. Then there's a possibility that this could not be necessarily permitted as of right.
So Nico, what the
Um,
statute actually states is shall not include removal or deposition of significant amounts of material from or onto a wetland or water course,
Right.
which would encompass both removing stuff as well as introducing new things. It would be great if you were able to look at this while we were having the meeting.
No, I know what the regulations say. I've read them many times. I know exactly what they say. So removal or deposition of material, right? So,
That would include
oh, sorry, Selena. So, got my puppy here. So if a significant amount of material was introduced, deposited on the site, then it would change the flow of the water course. So I don't know. My point is basically like there are lots of erosion issues that happen, and we've seen a lot recently. So I'm driving in Vermont, Selena. So, and we have gotten record amounts of rainfall this summer and fall. And significant erosion and damage has resulted in the rivers of New England. Like I just witnessed some really bad erosion that's happening up in Vermont. Like significant mountainsides that are basically collapsing, which is crazy. But you know, so on a smaller scale in Limekiln Brook, we still have a lot of significant rainfall effects that are coming in. They're going to continue to come. So it's kind of only logical that a homeowner would want to protect their land from eroding, right? If they could. So that's part of why it's permitted as of right to do this. The question is if they don't use, for me, okay, that if they don't use the materials that are on site, you know, and because basically you're not adding or subtracting anything. If you take the rock out of the river and you put it on the side of the river, you have a zero net change or alteration in the volume flow.
Excuse me.
So if any significant amount, any amount deposited on site into a wetland would be significant, I would argue, Mr. Marcus, even though you had stated that, you know, perhaps it was not a significant amount. So that's up for debate. But I just took some notes. Thank you guys for listening.
okay.
So I'm almost done. Yeah.
Go ahead
So
and finish
then
up.
the question still, I'm almost done, Danielle. I'm sorry. Thank you. I don't mind this being a conversation, but since we have to wait for everybody to speak, then I have to say what I have to say, right? So the stones came from off-site. We just found out. So then the question becomes, you know, are there changes to the opposite bank? So has that deposition of material altered the opposite bank? If the river's rocks came out of the river, then it becomes a question of, well, who is responsible for the opposite bank anyway? It also should be noted that there are stone works on the opposite riverbank from Mr. Bjorken's house on Mr. Blanchett's property that I noticed. They were installed, I don't know when, like in the recent historical past. You know, quite distinct stone terraces that essentially are retaining walls that protect part of his yard and the bank there. I'm sure we have the.
Hold on a second, Mr. Blanchett. I'm absolutely going to give you an opportunity to speak into the floor as well.
So thank you. So I'm sure we have, you know, pictures of that. So then that was done a while ago. And that's a permitted as a right thing. The question, what seems to me like the really important thing is like who's responsible for the now eroding part of the bank, which I think is like a little further, you know, downstream, so to speak. My flow direction is right. On the east side of the river, looked like there's a hill there, a forested hillside. Whose property is that? Who's responsible for that? If that erodes, if a significant amount of material was in fact introduced on site to build, then we may have an issue. But I wouldn't see an issue necessarily, and I would see it as permitted as of right if it was removed, if the stones were taken and placed outside, you know, in the same river, then that's an activity I would consider permitted as of right, just because of the natural course of that. You're not adding anything to the equation. But yeah, I guess that's it. Thank you. If you guys have any questions to ask me.
Okay. Thank you, Nico.
Thanks, Dana.
Some comments that you wanted to add?
Were you asking me? I'm sorry.
Yes, I'm sorry. Yep.
Yep.
Did you have some comments?
No. Yeah, there's a couple things. First, I always enjoy when Attorney Marcus comes and educates us on how we're supposed to be voting for the wetlands. So I am not a lawyer. You know, Mr. Birkin, I believe, has been said he does a lot of this work, so he would have known to come to the wetland board before doing this work. As Dave pointed out, this was brought to us because the neighbor had approached Mr. Birkin numerous times to cease and desist because it was destroying his side of the brook, eroding his side of the brook. He tried to take care of it on his own, could not, so he broached the town. There's nothing that, I don't know, I'm not a lawyer, but I can't see anything being said, hey, it's okay, you could do work on your property. If you destroy the other property, well, that's what happens. You know, I don't see that happening. You know, you know, rocks were taken out of the brook, rocks were brought in. You change the flow of the course of the brook. A bridge was constructed there. That's not allowed. So, you know, to Dave's point, we had a hearing on all this. He was allowed to present. He's been asked numerous times by this board to come to the board, explain his plan. Numerous times, the board has been extremely patient with him. I do have a question, Dave. Is there a application right now for this, because it has to be closed tonight?
I'm sorry?
You wanted to know if we had.
There is an application right now, correct?
Yeah,
Yes.
this is part of the site plan review process.
Right, and it has to be closed tonight, correct?
Correct.
Well,
All right, so
unless,
here's my recommendation. I'm not a lawyer. I don't feel this is a activity that should have taken place. We give him every opportunity to correct it. He has not provided the information that's needed to make a decision appropriately. So I'm in favor of closing this, denying the application, and letting the town lawyer figure it out. Again, I'm not a lawyer. You know, Mr. Marcus is a lot smarter than me. You know, the two lawyers can figure out, hopefully come back together. The bottom line is the neighbor's property is being affected and it needs to be corrected, so we can't be detrimental to his property as well. Thank you.
Thanks, Pat. Jay, did you have any comments that you wanted to bring up tonight?
Yeah. So I guess for me, you know, this has been said before. The applicant has had plenty of opportunity to come before the commission and state his position and what he's doing, and that's just been neglected up until this point. You know, I get the point, the permitted uses and maintenance. You know, if this was just strictly removing blockages in the stream or replacing rocks or boulders that had eroded into the waterway and were just moved back up on the bank, I'd see no problem with it. But the fact that we're bringing in new material and really changing the flow of the river, that's really, to me, where the issue comes down. You know, I'm also a landscaper, and we do a lot of this type of work. And we do a lot of work, you know, on First Light properties, and any of this type of stuff needs to go before First Light or whoever else to get permission. And I see this no different. You know, it, like I said, if this would have just been, oh, some rocks fell down in the river, obstructing the river, we're going to pull it back up on the bank to prevent the bank from eroding, I'd see no problem. But with, you know, this, we're bringing in loads and loads of boulders from Newtown and really reshaping the bank. That's, I think, where the issue lies, and especially that the applicant has had plenty of opportunities to come before us prior to this point, and here we are in the 11th hour with this. So I would join Patrick in his comments on where to proceed.
Okay, thank you, Jay. I'll keep my comments brief, and then I'll be happy to give Mr. Blanchett an opportunity to speak as well if he would like to do so. I think most of what I would say has already been stated by other members of the commission and by Dave. I think it's fairly clear from my opinion that it's not a permitted right of use for a few reasons. One is it wasn't brought up properly, and we weren't given the opportunity to assess whether it was going to be considered a permitted right of use before the construction began. And I have a big problem with 32C, where it specifically talks about including, but shall not include removal or deposition of significant amounts of material from or onto a wetland or water course. Having been out to a site visit to view the property and to view the construction, I agree that subjective can be, I'm sorry, that significant can be a subjective term, but this doesn't even come close to the bar for me. There is definitely a significant amount of materials that have been added there. So that's not close for me. And so that's where I stand on that.
Did you want to, I thought you were going to offer.
I am.
Mr. Blanchett.
Yep. Are you good?
Just to embellish a couple comments made by the commissioners. The language of the complaint and the origin for where materials may have come from does not change the fundamental issue at hand, which is that fill or in this case rocks were put in a place where nature otherwise had not brought them. Nature is given a lot of leeway because nature unfortunately doesn't have the ability to come before you as an applicant. You see this in the past with beavers, where they will construct dams, and the beaver is not going to submit an application and say, I want to live here. So it's if someone wants to go through the act of removing them for the purpose of either their of either improving their property or trying to prevent a concern or a public safety, health, or welfare hazard, that the commission should consider whether or not they would treat that any differently than someone trying to for lack of better words, add rocks to the bank of a water course. The commission should also note that your violations are handled on a case-by-case basis. So whatever position or whatever questions you have, you should consider that you're not asking them to be punitive in any way towards the property owner. I think it's been clear that you want to help the applicant try to get through this process, but you have expressed how you cannot help them without having ample information to review as to what it is that they are doing. The one last thing is, when it comes to an alteration and the net displacements, I guess to throw back in previous applications, like I said, and how we should, which is contrasting what I said about reviewing things by case basis. This is why on applications, there's a request for the amount of material that was brought in from outside of the site. The same goes for material that's being taken away, and have that stand out with respect to material that has been displaced from within the site. Because even if the net amount of material has not changed, it is still not in a place where it would otherwise be. So if just as an example, if someone were trying to construct a single family dwelling and they had to dig out a basement and they don't want to cart any of the material away, they're going to have to excavate for the basement and possibly regrade that material. The commission will still see those volumes of the material that was displaced, because it's important to know how much it was and where it's going. And specifically in this case, if the material is being relocated to perhaps alter the flow of the water course, the commission should know how much and why and what effect it has. That's all I have for the moment, Madam Chair.
Thank you, Dave. Mr. Blanchett, did you want to add comments?
I'm good. Yeah.
Okay.
I would ask, Madam Chair, if Mr. Marcus has any response comments.
If I have the opportunity. Again, the comments from some of the commission members really don't comport with what exists out on the site. So first of all, and Patrick indicated that the bridge is a problem. There is no bridge.
There was when we did a site walk, respectfully.
There was a working platform. That's not a bridge. That's a platform that was meant to access. If you're going to, for example, take dead trees out of a river,
Regardless of examples, a
you have
bridge,
to get to them.
a bridge goes across
Yeah.
a water course to go from one side to the other. So respectfully, he created a passage from one
Yeah.
side to the other, which I think is a reasonable thing to call a bridge.
But to say that
Temporary or not.
we're not applying for a bridge, and that's not part of the landscaping plan. That's like saying that you bring your backhoe in to do the work, then it's part of the project. It's not. That's a piece of equipment. So it's not. It's in the nature of a bridge. Yeah, it gets from one back, but it doesn't go in the water. Quite honestly, it just sits on rocks on either side.
So we have
Got a cable.
photographs of it in the water, in the record.
Yeah, let me pull those up.
Okay.
It never reached the other side.
We walked across the bridge from one side to the other when we came out to do your site walk. So respectfully, I'm going to have to disagree with that.
Well, then you stepped off of the end of the bridge.
It never
onto the-
touched. That's okay. It never really rested on the other bank. It doesn't. There was a cable holding it up. It is a piece of equipment in the nature of a bridge. But anyway, the fact of the matter is, I don't want to belabor this. If the concern for the commission is that there's going to be a bridge there and that's not right, there
I
isn't
don't
going.
think, Pat, was that your concern that the bridge was going to be a part of the final construction project?
My concern is we have a lot of questions that were not answered. We were not told, or if the bridge would stay, be removed, or anything to that effect. And we gave plenty of opportunity to understand what the final outcome was to be. So I have to go by what was there during the site walk. The site walk I got from one side of the stream to the other side on a man-made structure. There was cables there. It was a bridge that you walked across. I don't think any of the commission members would have walked across it if it wasn't a man-made structure. And that's fine if it's going to come out. Again, we haven't had the opportunity in the process to understand what the outcome would be.
Okay, so I'll get to that in a second. The other is, a lot of people have kept talking about changing the course of the river. There is no evidence of that river ever being changed as to its course. So I guess if the commission wants to point out where the river has changed course, you're going to have to do another on-site inspection and point it out to yours truly and to Mr. Jordan, because
Gonna show up?
it doesn't, the river appears to be flowing exactly where it has always flowed. Anyway, the other issue is, and a lot of people, a number of commission members have said, use that phrase, change the flow of the river. I don't think that's the facts. And there's nothing in your record that supports that other than your observations. There's some question about what you can do when you landscape. And that's interesting because, there's nothing in this exemption that says landscaping has to be limited to use of materials that are native to the actual site that you're landscaping, which would be a kind of an unusual limitation on residential landscaping, because quite honestly, a lot of landscaping material comes from off-site.
Agreed.
Rocks for building stone walls,
Mhm.
patios. So the suggestion, and actually the chair actually said that rocks were placed, oh no, it's David who said that. Rocks were placed where nature didn't intend them. Well, that's right. He's building stone walls. I mean, I don't know that, I mean, there are natural stone walls, which are amazing when you see them, but they were created by the glaciers coming through years ago. But a lot of stone walls, including farmers' walls, etc., you're right, they're man-made. They take the material, they pile it up. So I'm not sure that that's an issue with, it isn't landscaping. We're talking about terms here that are given their common meaning. They're not defined in the act itself, nor in the regulations. So we give our common sense understanding of landscaping, and quite honestly, my experience with a lot of landscapers is that they bring the materials in. They don't use just what's there. If there's stuff they can use on the site, they use it. Otherwise, they bring their own. So that doesn't change the nature of the exemption or the non-regulated activity. At the end of the day, again, a lot of claims that rocks were removed, but there's no evidence of rocks being removed from the river other than Mr. Jordan saying that he took a couple, 2 or 3, and moved that. And actually, when I was on site, he showed me where a rock just slid back along the bank. It rolled out, and he moved it back. But that's hardly a significant amount of deposition of material in the water course itself. So at the end of the day, the claim is that the applicant hasn't made it clear what he's doing, and that the applicant hasn't had any expert testimony or evidence placed. The JMM report, in fact, Jim does have the qualifications of an expert in his field, and he has analyzed the property, analyzed the work, and he's opined that, in fact, that there are no impacts. And that's what you're really worried about. And although no impacts have accrued to the regulated resources, he then says, on top of it, you should make sure that none occur in the future, and you should plant it, which Mr. Jordan is perfectly willing to do. So at this point, I mean, I can see that the matter has got to head to a judicial determination of these kind of vague terms based on what you have in your record. And that's an option that I was aware of when I came into this case at the 11th hour. They're absolutely correct. The commentary, I'm here at the 11th hour. But the opportunity for the commission is that they don't have to deny this permit, because quite honestly, I'm not sure we need the permit to begin with. What I would suggest is that the commission maintain a dialogue by sending its representative out to the site to determine if there are actually rocks that you want us to toss back in the river. Just point out which rocks you want and where you want them, and we'll put them there. That's as simple as that. I don't think that's the issue, but there was a lot of commentary on that. The bridge, as I say, is not a permanent structure. It's a working platform that really looks like a bridge, but doesn't rest on the two shores. So much for it meets the dictionary definition of a bridge. But anyway, that's again arguing about issues that are superfluous to the real issue here. The real issue is there's a landscaping project going on. If you want to participate in what you think can be done and can't be done, we're perfectly willing to do that. If you feel that you want to deny the application, I'd suggest you do it without prejudice, because quite honestly, I don't think it was properly brought. If you want to say that you can't landscape in the town of Bethel after the fact, you can't come in and correct your failure to notify the commission, I would take that up on appeal, because I don't think that's the law in Connecticut. The fact of the matter is that you have before you a stated intention and to complete a landscaping project that falls within 3.2 and 3.3. And if you want to litigate that, that's fine. If you want to complete the project in the best environmental way, let's do it that way, because that's where I started. I said, I disagree with the finding that there's a violation, but at the end of the day, we want to come out of this meeting with this commission with a completed project that's not punitive, but, and by the way, that section of the river before this project started was seriously deteriorated. These banks were eroded, and there was a lot of garbage, debris, natural debris floating in the river, and it's been cleaned up. So it's not that anything has been done to harm the environment. The question is, do you want to just leave it in an unfinished state, or are we going to finish it? So that's our position. I don't want to argue these issues, as I say, if we want to. And the other thing is, if there's a question of how far does a residential landscaping project go, then let's refer it to council. You have two lawyers who are now representing the town in this area. Both of them are competent, and both of them are familiar with this type of work. So we had this issue the other night before the ZBA, where basically the ZBA was in Bethel. The ZBA was asked to decide a legal issue, and when they closed the hearing, the first thing they did is they said, we're referring it to Chuck Anders, to which I commented, amen. I would suggest the same thing here. If it's a question of trying to define, because quite honestly, if you take this position with this applicant, you can go around the town of Bethel and you can find people whose neighbors say, hey, they got equipment on their property, complain to you, and voila, people have already violated the regulations if they are close to a wetlands or water course and they don't even know it. And that is not the purpose of the commission's work. So there are precedents that you got to worry about. My proposal is that this proceeding is brought to a close and we proceed to go out and come up with a plan that the commission wants to participate in. If you do, otherwise, we'll finish landscaping plan. So those stone walls.
I think definitely I can say that I'm comfortable speaking for all of the commission when I say that we definitely agree with you that we would like this project to not have a negative impact on the area. We completed well. Exactly what that looks like, but that will be yet to be determined. Mr. Blanchett, I wanted to offer you one more opportunity to speak. It looked like you might have changed your mind.
Could you approach the dais if you are going to offer comment, Mr. Blanchett? And just state your name and address for the record, please.
Brian Blanchett, 4 Old Hollywood Road.
Thank you.
Mr. Marcus, I was curious.
Can you just do me a favor and direct your comments at the?
Oh,
He does, he does,
Okay.
I'm a guest.
Oh, we can?
Madam Chair, he does have the right to cross.
My
examine.
God.
No, if we want to work, right?
It's okay. I'm just learning all the regulations. Go ahead.
No, so you're saying that you feel that this is an unregulated activity?
It falls under section 3.2 and 3.3. And one is called use permitted as of right.
Okay.
And the other is called the exact term from the regulations. The other is called non-regulated. I
Okay.
may use the word un.
Alright.
It's really non-regulated.
So I just wanted, I'm not sure if the commission's aware, but if you do deem an act non-regulated, you can't impose any conditions under the,
I
what
think,
the scope of.
I think we're past the point
Yeah,
where we're
so-
even looking at that as
Okay.
an issue at the table, because that would have had to have been brought before us beforehand. So
Okay.
I'm
Yeah,
not sure
I-
it's relevant to
so I
speak
don't-
about it, but if
yeah,
you'd
I
like
guess-
to.
No, I was just.
Mhm.
So, other than that, just if you guys had an actual plan that addressed the entirety of the violation, meaning that all the portion of the western side of the river that had been disturbed, it'd be better for everybody, so we could, like you said, get to the end of the tunnel with this.
Again, we offered to throw back into the river any debris that we took out, if you want us to, including any boulders that you think were taken out, and any tree stumps.
Now, what about the stones that were brought in? I mean, if armoring the bank, it's
Yeah,
changing,
no. That
you know,
that
so-
we were gonna do. We are going to reinforce that bank so it doesn't erode.
and that's gonna change the flood capacity, correct?
No, not at all. Not at all.
None.
No, because we're not filling in the floodplain. The bank of the river is just that. It's a bank, and the water will still overrun it. As a matter of fact, I don't know if you've seen pictures, but there was a storm in early December, and that's what it looks like. I mean, the river,
Yeah.
the river rubbed over the banks. Now it's
Before the wall went there, though, the water would breach to the south of that structure, and it would go around the building. But anyway, so I was just hoping you guys
That's
would maybe
worse.
be able to come up with another an actual way to address this, so we could acknowledge what actually was going on, so we could fix it. So,
to your point, if it's an unregulated or a non-regulated activity, or it's as of right, you're right, the commission doesn't have any say in what goes on. The position of the applicant is he made an error. He didn't come to the commission last September. As a result of that, we are willing to work with the commission to correct the error of our way, and we will accept any recommendations, reasonable, not any, but reasonable recommendations to do work that the commission feels improves the environmental quality of the project. We'll do that. And we're doing it voluntarily, which we can do. But the chair is correct. You can't oppose it but we made a mistake. We're trying to correct the problem.
well, so, yeah, but if we don't acknowledge the significant deposition of material, then you'll be ultimately submitting an application that doesn't fall under the sections that you're referring to,
Yeah, I mean, if the
because
Connecticut,
they're automatically disqualified.
if we go to court over this, and the Connecticut court says, no, we deem that there were significant amounts of material, it's clear on the record, then we have to come back and file a new application all over again.
Okay. All right, well,
But I'm trying to avoid all that, save time, energy, money, and actually do something that's environmentally correct, which is to close up.
so why do we need the court to acknowledge that then?
I don't, I'm suggesting the alternative. That's what I'm saying. That's the alternative.
So we've been asking for a plan all through the entire course of having this open, and we have yet to receive, to my knowledge, a plan of what was done and what the applicant wants to do in the future.
Well, I guess the question is, we can get you that. The question is the detail. It's hard for somebody to come out, the applicant can tell you what he did, and we can write that out in a narrative and put it on a drawing. But, it's hard to get somebody from outside to come in and analyze what was done, other than JMM who did it. I mean, he did.
He wasn't
with
looking
the-
structurally at the work that was done. So again, respectfully, we are at the end game on this application and it has been open for a substantial amount of time.
You
And
bet.
we've been asking for that information all throughout the course of the application and we have not received it yet,
I
which
just
makes
showed
it,
up. I know.
yeah, no, and I'm just stating for the record that that's where
I
we're
don't
at.
disagree with it. I don't,
So-
but I'm saying the alternative is, if you need to deny this, you could deny it without prejudice, with the understanding that the applicant will work with the commission and its representative, and we'll try to come up with the answers to the question. But, you know, that seems to me the practical way of going.
Noted.
Do
And
you think that the appropriate way to initially get that going would be actually to acknowledge all the stuff that's occurred there and not say that we took 2 stones out of the river?
We'll try. We'll
You know what I
try.
mean? So that maybe could help us.
okay,
We'll
so if
I know we've had this conversation
Not-
now, you guys, that's why I just.
not to interrupt, I'm sorry. But if the commission was to opt to deny this application without prejudice, per the dialogue that has been exchanged amongst you three, the commission should consider what kind of timeline would be appropriate for the applicants to give you the materials that the commission has thus far deemed insufficient for them to render a decision and actually have productive dialogue, for lack of better words.
So it's my
Dave,
understanding that I'm sorry, Pat, I'll give you a second.
no, please go.
It's my understanding that based on what attorney stated, that the applicant would like to move forward as quickly as possible, seeing
Okay.
how the weather is turning. So I think he would probably be amenable to turning around that information relatively quickly.
Absolutely, absolutely.
Okay,
And I would say that would be in everyone's best interest.
okay.
If that would be the
I can
course.
promise you, David, as soon as ski season's over, you'll have it.
What's that? That's it.
Pat, did you want to comment?
Dave, question, if this is denied without prejudice, when they come back, it comes through the approval process again, correct? Like a new application.
That's essentially what the intent would be, yes.
And it would reset the clock then.
Correct.
You would effectively be treating this as a new application.
No, absolutely, because I agree with Mr. Marcus. He's coming in at the 11.5 hour. Talking about another site walk, we couldn't do it if we wanted to. We have to have this closed tonight. We couldn't do it if we wanted to. And my personal opinion, more work has to be done than a couple rocks thrown back into the stream. But, and the question on if a permit is required or not, again, Mr. Marcus is a very talented lawyer. We have very talented lawyers. I don't know the law. At the same time, let it go to legal. Can we do that for them to find out legally if a permit's required at the same time that they're reapplying?
I
Or does
think
one-
if the commission is talking in this vein, Mr. Purfort, what I would recommend to the commission is that they perhaps consider having a council, whether or not it is the town's council or land use council, involved as part of the process, not necessarily for every meeting, but just to at least make sure that we don't fall into this same course of action again. And that,
I just,
go ahead.
I just want to, if we do deny it, I want to make sure the legal part of it's going at the same time, because in good faith, I have not seen anything from the applicant till the last, literally 11:59, a minute before deadline, more information. If this was held at a show cause hearing, this could have been resolved by now. Plans could have been in place to fix. A minute before doesn't do it. We tried tremendously to get the applicant to provide the information. So again, I have no problem with them reapplying, resetting the clock. Absolutely. If they want to come and work with us, awesome. But at the same time, I want to make sure the other side at this time is being done at the same time.
I'm gonna make life easy. I'm withdrawing the application this evening. That application is withdrawn. Here.
Okay.
Doesn't require any action. We're gonna go back to the commission with a proper process, and we're gonna start that immediately.
Okay.
This application, it was filed without my involvement originally with the attempt to comply with a cease and desist order, correction order. I'm gonna withdraw that. We're gonna do this the way I think, and we'll do it through town council, if you would like, and make sure that the process that we're gonna follow is agreeable to all sides.
What
Okay.
are you gonna, what section, there's two sections that
Yeah,
you
we're
noted?
gonna go into 3.2, 3.3, and we're gonna decide if we provide the proper material to support that.
So they're gonna try and reopen the process
But that's
using
gonna,
it as right.
but they're gonna argue that they didn't alter the water course. We've already established that.
So
Doug, you're
that,
gonna have to establish that for the record, because it has not been established. And I'm gonna agree with the neighbor, maybe we can hire a limnologist that we can agree on to use an expert, and you're gonna pay a piece of, and we'll pay a piece of, and we'll get this, if it's important to the commission,
What about the other neighbor whose property is working on?
he can join in too.
But how, I mean,
He can join in.
I think we're going in the right direction,
Yeah.
but for you to say you're gonna.
one
we're
step at a
not-
time.
That's starting over though.
Yep.
I mean, that's.
Well, we're not quite starting over,
But is that
we're
the only
starting from work that has been done.
It-
We're starting from.
It should be noted that all the information that has been collected thus far just doesn't go away.
Yeah, and I mean,
It's
We have-
all still there. Yeah,
Okay.
I
so we're
think,
just gonna go through another review process.
What's
We're
gonna
gonna
happen,
finish.
my understanding is that they're gonna reopen and they're gonna apply for right of use, and then there's going to be a determination as to whether or not we accept it as right of use.
Okay.
And then if it is not accepted as right of use, then there will be an appropriate, complete application filed again. Yes. And then we will go through the review process.
Or an appeal, one or the other. Yeah, that's a possibility too. I don't know.
Oh,
Yeah.
okay, fair enough.
Yeah.
So,
You
yeah,
can't
we
do
are
that to
starting
people.
over. I have a question for
Yes,
you, and I understand that you may not be able to provide me with this information exactly, but can you give me an intention on how long it's going to take you before you file for your right of use?
We're gonna do it the next couple of weeks. I mean, it's long, it's not gonna take us long to do.
Is it gonna contain, it's not gonna have to contain any of the stuff in your report or anything like that?
it's at the commission's discretion. If they need the information to determine the uses as of right, it must be provided to them.
I mean, if it was crucial before, it's gotta be crucial now,
I-
regardless of what the use is.
I don't
It's
think there's
still-
anything to imply that requirement has since changed.
So what has changed then? You guys, so you're just gonna come up with the stuff that that you don't have yet? that you will-
What's changed is the procedure. We're gonna follow the regulations properly. Period. We're gonna try. And then it's gonna be determined as to whether we did. I'm perfectly willing to do that.
Yeah, but to save us time between now and the next meeting, you guys have an intention of having a PE and the entire plan is gonna entail the entire portion of the bank, just stuff that we can, right? So there's not anything lost since you just got involved and haven't done a site walk yet?
If if it's determined that a landscaping project in the town of Bethel has to be prepared by a professional engineer,
I'm talking about
getting a
restoration.
certification, I'm saying, we'll do it. We'll
Okay.
do whatever is across the town. Right now, there is no requirement that you get it.
But so what are you gonna,
It
Or
depends
even-
on the
even a
scope of the
license.
project, I think is really the piece that we're not talking about here. A landscaping project,
yeah,
there's
the
scope
landscaping,
involved.
we're not gonna
Exactly,
say this is not. this
So
isn't a
you're going to,
landscaping
you are going to
I'm gonna tell you
petition
what
that
the
this
scope
is
is.
considered a right of use
Yep.
landscape application, right? And then the commission will decide whether we agree with that determination or not.
And by the way, you gotta
So-
keep in mind that we're talking about a very small piece of property. This is a tiny parcel.
Well, regardless of
major-
that, it's something that we can discuss at the determination.
I'd just like to point out, if I'm correct, and Attorney Marcus, you may be able to answer, in the right of use conversation, the final outcome of the project has to be presented.
Absolutely.
Yeah,
We have-
so you'll see what both sides look like, what you're trying to accomplish. You'll see it there, and it may be in line with everybody's expectation to begin with and conform to wetland regulations at the same time. So
We already know from Jim McManus what he observed had been done. So we're gonna finish that. We can finish
You should have.
Well,
with an
Well, no, 'cause he-
application.
But
For-
he said only one little tiny thing was done. So I don't wanna get stuck in this again as far as, I'm not trying to steal a show here.
Well, you're gonna, again, the commission can bring in its own expert to say that more was done than
We
what
already
the
did
planner
that.
saw.
We already determined
Who was
that.
that? I didn't see it.
Stephen Danzer, well, he really didn't have anything to look at, but I mean, if,
That never affected Dr. Danza before. in its
okay,
report.
well, I mean,
And
that's,
and it should be noted for the record that that was not a expert that the commission procured.
no, that was,
That was at the behest of Mr. Blanchett. So the commission has the discretion to bring forth their own expert to weigh in on whatever is brought before them. It may be safe to say, as preemptive as this may seem about talking about an application before it even comes before the commission, would the commission like to have, how do I ask this question?
Invite.
No, invite's not the right word.
I do see your hand is up, Nico. I'll be with you. in a second.
Once the materials are submitted by the applicant, would the commission like to have an expert of their choosing review the materials that they've submitted in advance of when that meeting takes place?
I'd be in favor of that. Would that expert also be able to review the materials that we have been reviewing with this now withdrawn application?
I mean, if the applicant wants to include that for the record, which I don't see why they wouldn't.
I'm not sure what I want to include because I want to see the whole record before I do it. But we're going to comply with the regulations. And then if you want to have somebody look at the application, you have the discretion to do that. Yeah. As I say, we're treating it as a landscaping project.
Right, noted.
And if somebody says, well, that's not a landscaping project, then let the expert say, well, what is it?
Noted. All right, Nico, did you have something to add? Oh, we have an interloper.
Hey, yeah. Oh, thank you guys. The question that I had,
It should be on.
can everybody hear me?
Yes,
Yeah.
Nico?
Yes.
Okay, cool. The question I had is, I guess for Mr. Marcus, two things that I would want going forward for the next application, if that's what we do. One is to know the percentage of the stones that were used from the river to do the riverbank construction versus the percentage that were imported from offsite, if you could. And then also, I'd like to somehow make sure we have a hydrologic engineer, somebody who can essentially model the site for us, if that's what it comes to, or explain to us exactly the physics of the site. Excuse me, Selena. Thank you. And that would be good. And I don't know who's responsible for getting that, but that's, I think, what we need for this to be able to make a decision.
Yeah, that may be preemptive with respect to what the applicant is trying to seek, Mr. Jordan, because they're trying to say that their activity is exempt from the regulations. It would not perhaps require that.
I thought we were beyond that at this point.
We're resetting, Nico. So first they're going to bring before us a petition to consider this right of use, which would be a non-regulated activity. So
Oh,
we
so
are,
that's first. Oh, okay. So they're not going to reapply.
they
That's
may
what
end
we're going to get.
first. That's their first step.
you can't do that. They're already-
And does that? But Mr. Marcus said that didn't necessarily include
Like-
a.
Information, but we're going to
a
get an opportunity to bring it and then, right?
would that include a site plan?
If the commission warrants what the applicant wants to do as a regulated activity, then all of the requirements that are customary to submitting that kind of an application would be required.
But let me just tell you.
Well, I
you're
thought
right,
that's different.
we have to do.
Yes,
Yeah.
they're all outlined right
yeah.
here.
The regulations say you can't apply under that if you alter the water course also though. So I don't even understand why we're wasting our
So-
time with this right now. That's like,
We're not altering the water course, but we'll leave that
you already
aside.
did.
But
So-
okay, so basically it just says that to carry out the purposes prior to the commencement, we have to notify the commission on a form provided by it. So whatever your form provides, we're gonna follow. We're
But
gonna do
it's,
that.
but it's also noted as an exemption to an exemption, which states that you can do anything, all these uses under right or unregulated, but as soon as you deposit rocks and move substantial amounts of material and alter the water course, it doesn't fall underneath the section. Hence why, if you guys aren't gonna, you're just wasting everyone's time. If you're
We're gonna
apply
give
that
you
way.
the volumes of materials that we believe were
So
deposited.
you're gonna say
into
that
the
that was
river.
3 stones?
We're gonna give the volume of material that we think was taken out of the river. We're gonna give you the volume of rock that was dumped on the site for building stone walls. No, dumped on the site. It's still stored there, the big
Yeah,
pile.
it's
I don't
stored.
want to litigate
Okay,
this
yeah,
right
no, I
now.
understand.
I really don't.
But
So I understand,
We're gonna
but
file.
we're gonna start again, and I understand what your
Yeah, yeah,
concerns
I
are.
got you.
I
shouldn't
fully
even
understand
talk.
what your
I
cons-
apologize.
No,
I
it's
just-
okay, but
just we're going around in
Yep,
circles.
and I think we will continue to go around in
Yeah, I
circles.
agree.
So I'd
I'm
like
done.
to,
So it's worth the commission having a consensus.
Yep.
To have council weigh in on what the applicant wants to do.
well, we don't weigh in on whether he withdraws, they withdraw.
No, for whatever the applicant submits.
Mhm. Oh, to make it known what we
Got it.
want to be a part of that.
No, it's,
Oh, whether or not we feel like we're leaning towards accepting it
That's-
as right of use.
that's correct.
Okay.
That's correct.
All right. Did you guys all get that up there? Okay, so, Dave has suggested that I get a feel for the room with the commission to see where we would lean if the applicant they have withdrawn this application. If they were to bring back a petition, would that be the right word
No, an application
for right of
to,
use?
It's a different type of application. It's a-
Okay, it's considered an application. Okay,
Yeah.
so an application under the heading of right of use, non-regulated
to determine
activity.
whether or not their proposed use is as of right.
Thank you. To determine proposed uses as of right.
I think either way, they're gonna come back with that. They're either gonna come to us or they'll go to legal counsel, have you. This petition or whatever, will it show what the final outcome would be? Condition of the property.
Yes.
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 So my hope is, I mean, either way, it's not wasting time because it's gonna go either to us or the legal, one of the two. So my hope is when the final plan comes in, which we've been asking for, it actually meets what we're looking for. It meets what the neighbors are looking for, and it's, everyone working together to get it resolved in a nice way. So I am fine with that.
Okay.
So you'd be in favor of them presenting a new application for permitted right of use?
Well,
Is that what you're
well,
saying?
no.
He can present
I know.
Right,
Is that what
but
you're asking?
No, I'm asking if the commission wants to have council partake.
Oh.
Absolutely.
Yes.
Because
Yes.
Because
yes.
I
We need to
am
make
not
sure
a-
that we're not going to be liable.
I am not a Neil Marcus.
No,
And-
you're right.
So,
It's easy.
it could be worth the commission considering having such a,
Legal counsel.
correct.
Okay, I hear Pat is in favor. I heard Nico, I believe, also state that he was in favor. Jay?
Yes.
Okay,
Yeah, so also in favor.
Okay,
Okay.
I as well.
so then for the next regular meeting, which is when I assume this application will be submitted, that would be
March 25th.
March 25th. I will make sure.
I'm not sure you'll have it March 25th because that doesn't give us a lot of time to, well, March 25th. Yeah, we're good.
Yes.
We're good.
Okay.
We're good.
Okay.
Very good.
Well, we don't have to put anything on the calendar because it's on an application yet. So.
No, because it's a regular meeting.
Right. So
Okay.
it's just when Mr. Marcus files it, then you'll know bring in counsel then. Or attorney Marcus, sorry.
We're gonna work on it.
Okay.
Okay.
Excellent.
gentlemen.
Thank you. Thank you.
Okay, moving on down our agenda for this evening. Looks like we have
Exhausted.
Have a
some.
good night, everybody.
Good
Good
night.
night, Mr. Blanchett. Good night, Mr. Bjorken. Good night, Attorney Marcus. Looks like we have
Good night,
some
Boone.
business items to attend to tonight.
Thank you. Good.
Thank you.
Thank you.
Have a good night.
Gentlemen, take care.
Thank you.
Amanda, thank you.
I wanted to confirm with the commission members virtually attending whether you had had the opportunity to review the meeting minutes from our last gathering. Pat, did you have a chance to review the meeting minutes?
Yes, I did.
Jay, did you have a chance to review the meeting minutes?
Yes.
Nico, did you have a chance to review the meeting minutes?
Yes.
Okay, I will entertain oh boy.
I make a motion to approve the meeting minutes from, I don't know the date,
1/22/24.
1/22/24 as written.
Do I hear a second?
Second.
Second.
Okay, all in favor? Oh, sorry, discussion? Okay, all in favor? We're gonna do
Aye.
roll.
Aye.
Okay, Nico, Jay?
Aye.
Aye for me as well.
So the motion
Motion
passes.
passes. And then we have staff report from Dave.
Okay, I'm gonna try to keep this short and quick. I'm giving myself less than 6 minutes. Here we go. A lot of what is under my section of the staff report, they are, notifications from the State Department of Energy and Environmental Protection for the application of aquatic pesticides. This is about the time that we get these every year, because a lot of people want to get on this work before the temperatures rise. So far you have notifications from DEEP for 10 Copper Square, 24 Kellogg Street, and 35 Walnut Hill Road. If you guys want to peruse those, not that there really needs to be much discussion that takes place on those. They're in the Google Drive for tonight's meeting. In the Wetlands Commission Continuing Education, just as a brief aside, I think it's worth noting that we have a new full member that has joined to take the former seat, or the seat of a former member, Don Taylor. His name is Paul Improda. He unfortunately could not join us tonight, otherwise he would be here. And I would say the same to him as I would say to you guys, in that I have a bunch of materials. I'm sure I've presented these a million times before. I'm going to do it again. There are guidelines from the state in terms of upland review area regulations and guides for how wetlands commissioners can conduct site plan reviews. These are really old. I don't have a lot of these to distribute, but I can send them to you electronically. So if you want to copy, and you don't want to wait until next meeting when they're in the Google Drive, let me know, because I'll give them to you. Last but not least, I wanted to go over the commission's application submission policy, not necessarily for any application in particular. I can table that. To get back to continuing education real quick. Last call for anyone who wants to attend the March 7th meeting of the Connecticut Association of Wetland Scientists. You must let me know very soon, because there are limited seats available, and you'd otherwise be put on a waiting list. It's $100. So I think we're non-members because we haven't renewed, otherwise it would be 75. So if you want to go to that, you may have to end up paying out of pocket, but if you want to be remunerated for that cost, let me know, because then we can have that addressed as a line item for continuing education at our next meeting. And that's all I've got, unless I've got any questions. 3 minutes.
Nice job.
Thanks.
All right, any further comments from commission members this evening? Nico says no, Jay says no, Pat is quiet. All right, any more public comments?
Yeah, I just wanted to make one public comment. Brian Blanchett, World Hollyville Road. So wanted to thank you guys for being involved in this process. And I also wanted to let you know that I took the 2024 DEEP Inlands Wetlands Municipal Comprehensive Training course. And it's available through UConn, and learn a lot of stuff on it. It was a 10-hour course. It took me 2 minutes to do it. And I think it would probably help you a lot in these meetings. So that's just wanted to put that out for you. And you know, that, wasn't a total waste of time. That's great.
That's awesome. That's the one I'd rather do rather than go to this conference, Dave. If we're
Okay.
But it'll lay out for you, you know, the difference between regulated, non-regulated, Nico, a lot of just things that
Yeah.
help you a lot.
That's that sounds good.
Yeah, just want to say thank you.
Thank you, Mr.
Thanks.
Wong.
Dave, can you put that course in the meeting minutes?
I'm sorry? Oh, yes.
Can you-
So you know what I can do? I can send that to you as an email to you commissioners.
Thank you.
And if you go on the Deep website, it's literally right under continuing it, and you click on it, there's a link.
Great.
But it was decent.
Thank you for bringing that to our
Yeah,
attention.
you're welcome. Have a good
Thank
night.
you.
guys.
Thank you,
Thank
you
you
as
so
well.
much.
All right, that's the end of our agenda. So I would entertain a motion to adjourn.
I just want to know why Nico's dog gets to go to Vermont skiing and I don't.
I got him here, man.
Yeah, I know.
We
I
just
make
got
a
the
motion
bird.
that we adjourn tonight's meeting.
Second.
All in favor?
Aye.
Thank you, guys.
All right,
Thank you, everyone.
and I will call this meeting to a close at 8:59 p.m. on February 26th.